is an accused in SC 396 of 2023, in crime number 22 of 2023, and 23 crime SC 503 of 2023, in crime number 23 of 2023. Full stop. This court granted bail in crime number 22 of 2023, 2023 on 14/11/2024, until such time the petitioner is in jail. Subsequently, the petitioner was remanded in judicial custody in SC 503 of 2023 on the ground of pendency of NBWs against him. The court is of the considering the petitioner is not appeared before the not attended the court below. According to the land counsel for the petitioner is not appeared before the in 503 of 2023 only on the ground of he was in judicial custody in other crime. Taking into consideration of the facts and circumstances of this case, this court is inclined to grant bail in favor of the petitioner in connection with the SC 503 of 2023 on the file of third additional senior civil judge from third additional chief judicial magistrate and Rangareddy district at LB Nagar, subject to condition that the petitioner shall now execute the how much 10,000 two sureties? Yes. The petitioner shall execute a personal bond for a sum of rupees 10,000 with two sureties for life sum issues to the satisfaction of third additional chief judicial magistrate Rangareddy district at LB Nagar, and the petitioner shall appear before the third additional chief magistrate Rangareddy district at LB Nagar in SC 503 of 2023 and each and every adjournment according to the criminal petition is disposed of. Yes, and also the petitioner shall abide by the conditions stipulated in 437(3) of CRPC presently 48. Yes. Now you are involved in major offences, 302. Yes. You are taking that is a good ground for acquittal, not for grant of bail. Yes.
Item number 42, Robertson, PP.
Where is Robertson? Now the morning of this in a case, we'll take up the matter on Thursday. Yes, Wednesday. Wait, at request post. At request post the Wednesday. Yes. Time please to fill one.
Patricia. Item number 55, Raju, PP.
Yes.
Lordship, I'm taking the anticipatory bail in this petition, my lords.
Yes.
The sections involved, my lords, are
Yes.
IPC 341, 290, and 324, my lords. The brief facts of the case are, my lords, the de facto complainant and the accused number 2, my lords, petitioner accused 2.
What are the offences?
Offences are, my lords, hurt, my lords, previous hurt with previous weapon, my lords. Dangerous weapon, sorry. Dangerous weapon. My lords, the de facto complainant and my family, we are relatives, my lords. The allegation is that I have bet the de facto complainant's husband with stick, my lords. And she claims that her husband has sustained previous hurt and injuries. And the medical report, I beg your lordship to kindly go through the page number 8, my lords. The medical report, my lords.
Yes.
Which says the injuries are simple in nature, not grievous, my lords. All the injuries, my lords. And whereas where the section is mentioned of the weapon of the injury caused, that also the section contains nil, my lords. And my lords, the last page now, I beg your lordship to kindly go.
LW1 received simple injuries. LW2 has received grievous injuries.
That is the allegation, my lords.
Not allegation, doesn't it?
MLC, my lords.
Not MLC.
Sorry, a medical report, my lords.
Medical report.
Yes. Here it is clearly written as simple, one grievous and one simple. Because they state that there is a fracture, my lords. The fracture, my humble submission is, it can also be a hairline fracture, my lords. I will come to that
Now,
point.
in orthopedic problem,
Yeah,
the hairline fracture is more dangerous.
My lords,
Now
I will
the
not-
major fracture that can be
One more
proved
question.
within
Yes,
a
madam.
span of particular days, surgery is
True, my lords. True, my lords.
the
I
airline
will-
fracture, then a very, now
I
the
know
person has to take
Yes,
bed
madam.
rest at least 6 weeks.
Great respect to your lordship's observation. Now, my lords, page number 9 also, simple, my lords. Now, my lords, last page, I beg to, lordships to kindly go through the last page, my lords.
No, petitioner and the de facto complainants are
We are
victims
relatives,
are
my lords.
relatives.
Relatives. The fact of the matter is, my lords, the
Any civil
petition.
disputes are pending.
Yes, my lordships, that's what I'm coming to. The de facto complainant clearly states in a complaint that there are disputes, property disputes pending between us, and the only humble submission is she is wreaking vengeance against me. They came in a tractor. In fact, the true fact is they have trespassed into my land, my lords. We are all into agriculture. Myself, my father, and my wife, and the de facto complainant and her husband. We all 5 of us. A scuffle broke out, my lords. In that case, some minor injuries were sustained, but later on they have exaggerated the complaint and they have made all false averments.
It's not a case for grant of anticipatory bail.
And my lords, humble submission, not your only simple sections are there, my lords. Last averment of the last page counter, my lords, kindly go through. Here, the prosecution says they have observed the crime scene minutely, but he did not found out any crime weapons in the scene of offense which were used by the accused and incorporated observation in crime detail form. Now, my lords, how can a grievous hurt happen without a weapon, my lords? That is the humble submission, my lords. My humble submission, my lords, there was the MSJ court, the district judge, additional DJ court has dismissed my AB, my lords. Therefore, I have come here begging your lordships for invoking the inherent jurisdiction, my lords.
This court is also
My
not-
lords, there are, my lords, one humble submission, my lords. In Dinesh Gupta versus State of UP, the Honorable Apex Court has reiterated that civil disputes need not be converted into criminal disputes.
Where you
They
are,
have,
where you are pleaded in your bail application, what the material of file,
my lords,
in respect of pendants of the civil dispute culminated into the criminal nature, any single averment in your bail application.
my lords,
So,
my lords, the de facto, oblige, my lords, the de facto complaint herself is claiming that there's a property dispute. The original
Really,
complaint, my
because
lords.
of property dispute amounts to civil dispute.
My lords,
We
property.
show
by and
single,
large,
we
it's
show
a civil
single
only, my lords.
averment that in a civil case are pending between the interested
I'm
parties.
not saying
Ah.
civil cases, my lord.
Then-
Dispute is there.
Now this is-
Inherent dispute is there, my lords.
Now there is
My lord.
LW2 got grievous injuries, head injury.
Not at all, my lords. The form also clearly states that medical prescription also, they are all simple injuries, my lords. My lords, the
Can you
offences
see-
are hardly 3 years, my
Page-
lords.
page number-
Anish Kumar is anyhow in play, my lords. I'm just begging your lordships.
Anish Kumar, how applies?
Because below 7 years, my lord, there is not even a single crime that is above 7 years in this, my lords.
All are
Yes, my lordships.
326 now. All are 7 years.
Not 326, only 324, my lords. And 290 is public nuisance.
No,
And
326 subsequently included, amended, altered the offense.
326, my lords.
No,
324 itself is not applicable here, my lords. My lords, kindly
Kindly
consider, my lords, because I'm just requesting your lordships.
Now the petitioner is not in service, he is only agriculturist, he is entitled to file a regular bail application.
My lords, some relief, my lords, any kind of, conditions will
What
be,
conditions?
whatever this honorable court deems fit, I'll be, complying, my lords. Kindly, my lords, I'm
Yes.
just begging your
No,
lordships.
listen, kindly see medical
I'm
reports.
ready to cooperate with the investigation, my lords, whatever your lordships deem
Bound
fit.
to every
Definitely, my lords, obliged. That's my,
Kindly see,
duty bound.
there is a fracture 493/27 something, there is medical knowledge,
Yes, my lords.
medical terms. Yes, public prosecutor, what do you say?
My lords, humble submission. He himself said that there is no weapon that has been
We don't
recovered
know.
yet now, my lords.
This is not a case for grant of anticipatory bail and counsel. Yes, friend. This court is not inclined.
My lords.
Yes,
one-
2927.
I beg your lordships to
2927 of 20. This is a fracture head injury case. 2927 of 2025. This criminal petition is filed seeking for a grant of anticipatory bail invoking the provisions of section 482 of BNSS. In crime number 255 of 2024 on the file of PS Manakundu Criminal District for the offences under section 341, 290, 324, read with section 34 of IPC. The case of the prosecution is that they heard M. Raju, learning counsel for the petitioner and learned assistant public prosecutor appearing in the learning counsel for the petitioner submits that the petitioner has not committed the alleged offence, committed the offence, and also the ingredients, all the offences section 341, 290, 324 are below 7 years. 7 years. Full stop. We further submitted that the there are no the LW1 and LW2 LW1 and LW, sorry, there are civil disputes are pending between the de facto complainants and the petitioner accused. To resolve these disputes, the de facto complainant lodged a complaint. We further submitted that the LW1 and LW2 not received received only simple injuries. Hence, the petitioner, for the subject petitioner residing in old age parents, and his presence is very much required. Hence, the petitioner is entitled for a grant of anticipatory bail. The account of the learned assistant public prosecutor submits that the initially crime number 255 of 2024 was registered under section 341, 290, 324, with 34 of IPC. After collecting the MC's medical reports, basing on the medical reports, the added section of law under section 326 of IPC, and hence the petitioner is not entitled to grant, and the investigation is under progress. The petitioner is not entitled to grant and I consider the various submissions made by the respective parties, and after perusing the material available on the audit, reveals that the LW1 received simple injuries and the LW2 received grievous injuries, and also there is a fracture to the LW2. Though the initially crime number crime registered for the offences under section 341, 290, 320, basing upon the subsequent medical records, the provision of law, section of law is altered, changed. Section the provision in 326 of IPC also added. So this court taking into consideration the facts, taking into consideration the facts and circumstances of the case, this court is not inclined to grant bail and state the bail, exercising the powers conferred under the provisions of so. Accordingly, the bail application is dismissed. Yes.
Any liberty for fresh circumstances in future?
No liberty is required. The BNSS provides, statute provides, no judicial order is required. Yes.
Item number 56, Mohan PT.